A Deal Gone Sour, the story of Raju and Ravish. Raju, a seasoned businessman, wanted to sell a prime piece of land. Ravish, a budding entrepreneur, was eager to buy. They met, negotiated, and struck a deal with a handshake. It was a verbal agreement built on trust and a shared understanding, or so they thought. Months passed and Ravish began making arrangements to develop the land. He invested heavily, drawing up plans and securing permits. He was confident, believing the deal was as good as done. Then came the call that shattered his dreams. Raju, citing a higher offer, backed out of their deal. He claimed their verbal agreement was not legally binding. Ravish was devastated. He had staked his future on this land and now it was slipping through his fingers. Desperate, he took Raju to court, hoping to salvage his investment and his future. The courtroom became a battleground of accusations and denials. Raju, composed and confident, argued that their verbal agreement was not enforceable. Ravish, his voice filled with desperation, pleaded with the judge, presenting evidence of his investment and Raju's initial agreement. The fate of their deal and Ravish's dreams hung precariously in the balance. Verbal agreements are often seen as informal, built on trust and mutual understanding. They are convenient, especially in casual settings. However, when it comes to high-stakes business deals, verbal agreements are fraught with danger. The lack of a written record creates fertile ground for misunderstandings. Memories can fade and interpretations can differ. What seems clear and agreed upon at one moment can become muddled with time. This ambiguity can lead to disputes, as seen in the case of Raju and Ravish. Without a written contract, it becomes a battle, he said. She said, each party may have a different recollection of the agreement's terms. Proving the existence and terms of a verbal agreement in court can be extremely difficult. It often comes down to one person's word against another's. Verbal agreements lack the certainty and finality of a written contract. This uncertainty can have devastating consequences, especially in high-value deals where the stakes are high and the potential for loss is significant. The gavel falls. Section 10, and the court's verdict. The courtroom was silent as the judge, his face etched with solemnity, prepared to deliver his verdict. He recounted the facts of the case, highlighting the verbal agreement between Raju and Ravish and the subsequent dispute. He acknowledged Ravish's investment and the potential loss he faced. Then he cited Section 10 of the Indian Contract Act, 1872. This section clearly states that an agreement without free consent and a lawful object is not a contract. In the absence of a written document, the court struggled to determine the existence of a valid contract between Raju and Ravish. The judge ruled in favor of Raju, stating that the lack of a written contract made it impossible to ascertain the terms of their agreement. He acknowledged the unfortunate situation, but emphasized that the court could not enforce an agreement that lacked the necessary legal validity. Ravish was devastated. The judge's words echoed in his ears, each syllable a hammer blow to his hopes. The weight of the law of the missing contract had crushed his dreams. He had learned a harsh lesson about the importance of written agreements, a lesson etched in the bitter ashes of his aspirations. The ink that binds. The importance of written contracts. The story of Raju and Ravish serves as a stark reminder of the importance of written contracts in business. A written contract signed by both parties is not just a piece of paper. It is a shield that protects the interests of all parties involved. Written contracts provide clarity. They outline the rights and obligations of each party, leaving no room for ambiguity. This clarity minimizes the risk of misunderstandings and disputes. In case of a dispute, a written contract serves as evidence. It can be presented in court to prove the existence of an agreement and its specific terms. This makes enforcing the agreement significantly easier and provides legal recourse for the aggrieved party. In the high-stakes world of business, where deals can make or break fortunes, relying on verbal agreements is akin to building a house on sand. It is an invitation to disaster. Putting agreements in writing, no matter how strong the sense of trust, is not just good practice. It is essential for mitigating risk and ensuring that agreements are legally binding and enforceable.